a balancing test. Otherwise, you wouldn't have the three-part test, and otherwise, you wouldn't have three parts to the test. It would be whatever these legislative bodies are, the enumerated ones, or whoever has appropriations authority. The legislature didn't do that. And let me respond to the concern that, well, then it would be the sheriff acting in his own capacity when the sheriff is negotiating. That's the whole point of the statute. The statute is not designed to implement a neutral body to determine legislative impasses. The cases I've already said, it's the same body. For example, let's use county employees as an example. For county employees, the city manager or the city mayor or county mayor has to consult with the county commission during negotiations, has to reflect the views of the county commissions during negotiations. So the county commission is not a neutral body in that example. It's only when there's an impasse reached and the union and the city or the county go up to the county commission that it then has to change hats. And cases have recognized that it's an awkward situation, that you have to change hats, but that's exactly what the legislature has provided. It did not provide for a neutral arbiter.
Well, that is true, but it's still not the party. The legislature, for example, if we're talking about the state level, the legislature isn't part of the negotiation process. It's the governor as the public employer and the particular union. And when those two parties reach impasse, it goes to the legislature to resolve it. Yes, the legislature has an interest, but it's not sitting across the table from the union itself.
But in the case of the legislature, if you apply the three-part test, the legislature appropriates funds, and unlike the situation here, the legislature does establish policy governing terms and conditions of employment through the enactment of the civil service system. Chapter 110 contains a litany of different statutes governing terms and conditions of employment. What state employees get regarding pay, vacations, all those kinds of things are in the Civil Service Code. So applying the test, the legislature is the legislative body for state employees. It has determined that. It hasn't determined that for county sheriffs. And when it enacted the Civil Service Code for Pasco County, it was especially designed for Pasco County, not for any other county. It could have said, you know what, we're going to design a civil service system just like we did for the state. We're going to determine all terms and conditions of employment like we did for state employees. And it may have done that for other counties. It did not do that here. Therefore, we have to apply the three-pronged test. Otherwise, you're reading it out of the statute. I see that I'm in my rebuttal time. I'll reserve the rest of my time for rebuttal. Thank you.
May it please the Court. I'm Tad Delegal on behalf of the Fraternal Order of Police, Florida State Lodge. Obviously, the sheriff concedes that he doesn't have the authority to appropriate funds. But I think what the sheriff confuses here is he confuses the power to supervise or the actual supervisory authority with what the statute says. The statute doesn't deal with how much supervisory authority is actually exercised. It deals with who has the authority to govern the terms and conditions of employment. And there's no doubt, as PERC ruled, that the county commission has the authority, one, and actually has governed the terms and conditions of employment. Certainly a county commission has the authority to provide for its employees, provide health benefits, provide other benefits to its employees. But here it is specifically authorized by the legislature and did provide a civil service bill. Contrary to what is said represented by the sheriff, the civil service bill is a great departure from the status quo with regard to the rights of deputy sheriffs. Deputy sheriffs have no right to appeal discipline, absent this civil service provision. They are not protected by a property interest in their employment. They have no right to challenge promotional decisions. What was established by the county commission in this case is in truth about as great as ever established in a civil service code or system. It's the essence of the right to appeal. I think it is certainly simply not correct to say that the county commission did not provide a great deal of authority or a great deal of governance of the terms and conditions of employment. But what we've got here is when you look at this test, the reason why the appropriations prong is the most important prong, and this court has repeatedly stated that, is by necessity. Multiple persons or entities are going to have control or supervision over terms and conditions of employment. Necessarily, a county commission, city commission, a supervisor, a division chief, all these people will have authority to put together rules and regulations, standards of conduct, rules of work, directing work, all the things that the sheriff has done. But in reality, only one entity will appropriate funds in the vast majority of situations. There could be times when you have a joint county enterprise or something like that, or a state county enterprise. But in those circumstances, it would probably fall to who has the most supervisory control over the employees. In this situation, in the vast majority of situations, since you are going to have multiple entities with authority over terms and conditions of employment, the dispositive issue is who appropriates the funds. And let me give you an example why that's important. The sheriff is saying, I have the most direct supervision of my deputies and therefore I should be a legislative body. The same rationale applies to the head of Parks and Recreations in the city of Tallahassee. Right now, that individual has the most direct supervisory authority over his employees. He doesn't appropriate funds, but according to the sheriff, that's not important. If that's the case, why not the head of the city pool division for the Parks and Recreation Department? Wouldn't he have more direct supervisory authority over his employees? For this reason, because it's an indeterminate test, it essentially leaves it up to PERC to say whoever we think is the best is the legislative body. That's not what the statute establishes. If we really go to the heart of the sheriff's office, the sheriff is arguing that the test doesn't require all three prongs. It requires you to read and as or to actually legislatively change the statute from the bench. And he states then, even if you buy that, which I do not think is warranted, the statute has been interpreted for over 30 years, and nobody in 30 years or 35 years has ever suggested that and means or. If you accept that, then what the sheriff is asking you to do is interject your preferences for those of PERCs.
Do we even need to get that far?
No.
When it appears that the county commission is one of the named entities in this statute?
Well, you know, this is obviously a very unique situation, or a different situation than was initially contemplated by the legislature. Okay, at the time, county sheriffs deputies were not entitled to collectively bargain. That is a fairly new development. But I do believe that the naming of a county commission does reflect the legislative intent, and that legislative intent is that this has to be an actual legislative body. You will see in the statute that not only does the legislative body have to authorize appropriations according to the collective bargaining agreement, it also has to actually change laws.
And was that your position in your brief?
Well, we didn't address that in the brief in terms of the county commission. But the county commission, the legislative body, when the chief executive officer negotiates a contract, if he negotiates something that is different than in the current state of the law, he has an obligation to go to the legislative body to have the law changed.
Okay, let's take this in this particular situation because this appears to be an unusual factual scenario.
Yes.
Let's work with me here.
Right.
Negotiations occur, impasse occurs. Let's say, for argument's sake, the county commission resolves the impasse in a manner that the sheriff is dissatisfied with. Can the sheriff then take that budgetary decision, and appeal it to the administration commission, is it?
No. No. The budgetary needs of the sheriff are based on line item issues And the sheriff is bound, as a chief executive officer, to attempt to fund the collective bargaining process. If the collective bargaining agreement, if the collective bargaining agreement results in a funding obligation, he is statutorily bound to fund that obligation.
So it stops there.
Right.
Does it matter then that in the general budgetary scheme and process that once the sheriff proposes his budget to the county commission, the commission says, yes, we like 99% of it, but we're going to change this, and the sheriff then has appeal rights over that decision?
Right.
Does that make a difference in in the collective bargaining
No, it
universe?
doesn't. We have to go back to the constitutional rights of deputies to collectively bargain. They have a right to negotiate over terms and conditions of employment. That process ends in a resolution, whether that be voluntarily or through impasse. And the legislature has set up a system. It's not a perfect system, but it's a system designed to effectuate the rights of those employees, those deputy sheriffs. And through that process, the sheriff is bound to try to fund that and to comply with the terms of the collective bargaining agreement. The same would be true if the sheriff voluntarily agreed to a financial obligation and the next year the county funds were depleted. Either he would have to go back and renegotiate or go to the county commission for additional funds or take other action. But the reality is that the budgeting process and the appeals process has nothing to do with the collective bargaining process. In this situation, the sheriff is asking you to substitute your judgment from that of PERC. PERC did analyze all three prongs, just as the sheriff requested or asserts that it should have done. And although the appropriations prong is most critical, it looked also as whether there was any authority over terms and conditions of employment. That should be undisputed. There is authority over terms and conditions of employment. The county commission did pass a civil service provision. It governs the terms and conditions of employment. It prevents termination at a whim. It prevents termination or discipline except for certain identified bases. And it prevents termination without cause. It also governs the way in which deputies may be promoted. But PERC, the sheriff in its, I think, fundamentally confuses supervisory authority with legislative body status. And I think that's the key here. A legislative body is not designed to necessarily supervise its employees, or supervise the employees of the unit over which it conducts legislative body duties. Just as the employees of independent branches of government on the state level go to the legislature for resolution of impasses, just as the comptroller or the attorney general has employees who collectively bargain, those independent branches of government can be told by the legislature essentially how impasses are resolved through collective bargaining. There is no bar to doing so, for the county commission doing so, just because the sheriff is a constitutional officer. And specifically with regard to the third prong, PERC held that the constitutional rights of deputy sheriffs were important for understanding the obligations or the identity of the legislative body. And it stated specifically in support of its ruling, if we were to conclude otherwise, the sheriff's employees would be left with no mechanism for resolving the impasse, and their constitutional right to collective bargaining would be rendered meaningless. Essentially, what is at stake here is the right to collectively bargain. Sheriffs are claiming that they can sit at the table, and then, if they don't like the result, they can impose the result individually. That status does not exist in terms of an individual who imposes imposes a contract on employees after negotiating the same contract. Effectively, this is going to kill collective bargaining if the sheriffs were deemed to be the legislative bodies. And for that reason, we urge you to accept the determination of PERC, very reasoned determination. PERC not only sent this back to the hearing officer, reconsidered it twice, entered multiple orders, but took this very seriously, held oral arguments, and held this way not just in this case, but also in the Clay County case, and held this way in a fashion consistent with 30 or 35 years of precedent. Thank you.
Thank you, counsel. Again, the union concedes that in its brief it doesn't argue that simply because the county commission is a named entity that has to be the legislative body. And if that were the case, if you were to hold that way, you'd be reading out of the statute the three-part test. So we have to go to the three-part test. The union also never answers the question of what happens in a case, which I propose is the case right before you, which is where one entity satisfies one prong, arguably, and another entity satisfies the other prong. What do you do then? The statute doesn't impose primacy in appropriations authority. It is a three-part test. In fact, it's designed to be a balancing test, a case-by-case approach. That's why the language, "and which, as the case may be, is the appropriate legislative body." You have to do that balancing act. The reason that the balancing act favors the sheriff is because otherwise the sheriff would just be the head of a county department and beholden to whatever the county commission would want the sheriff to do. The sheriff has to consult with the county commission and reflect its views during the negotiating process. That means that if you read the 700 pages of general orders in this case, all those can be the subject of collective bargaining. All those can result in an impasse during collective bargaining. Therefore, all of those must be consulted with the county commission if the union disagrees with any of those. That would strip the sheriff of his constitutional and legislative independence as an independent entity. Even the county commission says, we don't want this. We don't know anything about this. This is not our labor force. And maybe that's the most important point in the entire proceeding. It's not the county's labor force. And that's why it should be in the hands of somebody whose labor force it is, who knows about the negotiating process, who knows the importance of some of these provisions, some of the terms and conditions of employment. Thank you very much.
Thank you, counsel. That concludes our first case. We'll be in recess and again invite counsel to join us.